Ladies and gentlemen of the jury, we're already halfway through a long day, and I'm going to try to be as quick as I can. You've heard my partner, Mr. Ray, speak about a lot of facts in this case, but I want to speak to you now about the gravity of the situation. What we're hearing, what we're asking you to do, and why we're asking you to do it. You are a jury, and you're well aware of that. And I think Michael mentioned my books, and this is a book I got on my first day of law school. It's the Constitution of the United States of America. And there's an amendment, the Sixth Amendment to the Constitution, and it's been in place since 1789. And it is the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. I think we've given them a public trial. By an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, back then it would have been him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That's it. That is the bedrock of what we're doing. And it has been here for a very, very long time. I told you back in jury selection that I was only looking for my client 12 fair, impartial jurors honestly seeking the truth. And you all swore that that was you. And you have sat here very diligently, and you have paid attention and taken notes. And we've all noticed the effort and time that you've put into this. You have put in weeks of your life. You have missed time from your families, your jobs, to be here for this very, very heavy, important moment. And I also told you had another job. And I don't have my PowerPoints. I go with literally what you guys are going to have to work with. This is the charge that the judge is going to read to you once Ms. Frankish is finished speaking in this case. And your one job was to hold the state, and that's my job too, is to hold the state to their burden of proof. What is it? I'm just very clearly and succinctly going to read it to you, and then we'll talk about it. And I'm going to talk about some other elements of doubt that I think we should discuss, and I'm going to sit down, and the defense in this case will be over, and we're going to leave this to you, the jury, who is the most important group of people here. And I want to know, and I want to know this. I've been meaning to tell you this for weeks, and I can't tell you this. My client, you may notice that she does everybody else in the courtroom. They rise for you. They rise for the jury. We don't. Here's why. You are a jury of her peers. You're her peers. We're on the equal footing. The judge sits above us all as he represents the law. And we are all under the law. So when the judge walks in, the bailiff says, all rise, we rise for the judge as the representative of the law that we must live under. But our framers, who wrote this Constitution, and then, I had to go dig this up. We don't actually use these books much at the office, I'll admit that. The Constitution of the state of Georgia, which was actually adopted in 1983, so it's a much newer document. And it embodies the same principles in our modern time. Now, some may say 1983 was quite a long time ago, but not to me. It embodies it in our real time, in our real life to this day. Because our framers knew the government is, in fact, that's why we're here. That's why we're not part of Great Britain anymore. And almost every, even the modern democracies of Western Europe, kind of think we're nuts. They think we're crazy. Because we have 12 people who have no association with the government. And to come in here and decide the facts of a criminal matter, to check the government for that very reason. We left over there because we knew that the government should always be checked. Not just trusted implicitly with power. So I just wanted to explain to you, my client is not being disrespectful. I told her to do that because I so believe that we are equals. We are peers. The burden of proof. The defendant, and still is, by the way, presumed innocent. This case is not over. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with the presumption of innocence in his or her favor. The presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. 4 offenses in this case. No person shall be convicted of any crime unless and until each element of each crime is proven beyond a reasonable doubt. You're going to get this document. This is the indictment. These are the charges. They have to, every page of this indictment. Count 1, count 2, count 3, count 5. Every element, every word has to be proven in each count beyond a reasonable doubt. It can't just be maybe. I'm going to slow down. No person shall be convicted of any crime unless or until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever. And the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. So here it is. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from the consideration of the evidence, a lack of evidence, or a conflict of the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, unsatisfied, then that is a doubt of the law. And you must acquit the defendant. It says the word must. But if that doubt does not exist, if your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it is your duty to acquit the defendant. You will be given this. You'll be given a verdict form with 5 counts. Count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death of another. And count 5, making a false statement. It is, in fact, a heavy burden. But I contend to you that the state has not come close. Mr. Ray is far more eloquent than me. Mr. Ray is far more intelligent than me, and his brain works in a way I'm truly fortunate to have such a good partner. But he found that diagram years ago of the stairs. I've always used, I'll come down here and I use the bar. I say, a scintilla of evidence is down here. Probable cause or preponderance of the evidence is somewhere towards the middle of the bar. Clear and convincing evidence, which is not the standard in this case, is a little further up here. And then beyond a reasonable doubt is almost all the way here at the end of the bar. It's not all the way. I'm not saying it is. But I think this case that we have sat and listened to, and I think it is, the time was taken as needed to get through the case. For you to see every bit and every element of this case. But here's what I think you have clearly seen. And this is the first doubt that I propose to you. That the district attorney's office and the sheriff's office and all law enforcement involved in this case, from day one, from the early minutes of the 911 call, which let's think who made the 911 call. It was that man right there. He was in control from the very first minute of this case, Scott Farris. Scott Farris was always in control. And the fact that he had to immediately control the case, to me shows doubt. And I do believe it is a heavy doubt. When you look at everyone involved, every witness that you've heard testify, and that's another thing you need to know. You need to know that's your job, and you'll be charged on this as well. As a witness, you are to determine the credibility of the witness. Now, I'm going to read the charge. There's not a lot to this charge, and there's a reason why. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. What does that mean? Here's what that means. Here's what I propose to you. From the day we're born, in the early years of our life, we begin to get a feeling when we hear people talk. Because the words coming out of our mouth sometimes aren't true. For example, if I were to have a bag, and say I told you that this bag was full, instead of shoes, it was full of $1 million. Well, I'm going to take this half of this $1 million and give you guys the other half, and we're just going to leave. But here's what you know immediately. You know that if I had $1 million in this bag, I wouldn't be standing here talking to y'all. You know that. You have that feeling in your gut. Because you know, you sit here and watch this case, it's a bag full of shoes. It's a bag full of shoes that has no important evidence on it whatsoever, other than the fact that I think Melanie Farris cut her finger at some point and got blood on her shoes and her shirt. I think they've established that. And I think, and Mr. Ray did a very eloquent job, and I can go on and on, I'm not going to, because this case has got to come to an end. But when you think about law enforcement in this case, and their response immediately, let's go back to July the 5th. Let's go back to the time that Scott Farris, who's sitting right there, goes up to Detective Kuykendall, who's sitting right there, and he gets in his car for an hour and begins to tell him the story of the missing gun and his mother's affairs. And in opening statements, Mr. Fogus talked about circles. Circles getting big, smaller, smaller, smaller. And I think circles will be talked about too when we talk about Miss Harris. But those circles were controlled by one man. And that's Scott Farris. The investigation of this case became one-sided in that first afternoon. And I would contend to you everything that happened, and it's unfortunate for us in Cherokee County, for the jury, for Ms. Farris especially. that it was stuck that way. There was never any true regard or respect for the evidence that should have been gathered in this case. You saw it. You had 1, 2, 3. 3 locations on this massive property. You've been there. You've seen it. That were not checked. All the countless problems that Mr. Ray, unfortunately, had to kind of wrap it up because we have time limitations on now. We've been up here for weeks. We can't continue on. That's your job. You as a jury are allowed to go back to deliberate, and you get to go through every bit of this. And there's going to be some of you that believe this, and there's going to be some of you that believe that. And the judge will tell you that you are allowed to hold on to those beliefs and stand up for those beliefs. It is that standard that gives you the true check on our government. You are the democracy. You are it. We're having an election in a week. Nobody's got to go vote. There is no draft anymore. Some people don't have to pay taxes. But the one thing you got to do, and y'all know it better than anybody, is when you are compelled into jury service, you have to come. We literally saw an individual brought in here during this trial who tried to get out of jury duty. You've seen it. This is the last duty we have. Because it's that important. You can take any fact that we may have talked about, or even things we didn't talk about, and you argue about it back there. I'm not saying screaming and yelling, but if you got a belief, you state it. And you listen to other jurors, and you make sure they listen to you. It's truly that important. But I would contend to you that the fact that Thrasher, who came out of the crime scene, and I believe she testified something to the fact that this was essentially the first crime scene she'd ever been on. And she totally and completely failed in intaking the crime scene in the house. And that complete failure of that investigation alone, I think that's a doubt. I think going further into that day, and the fact that this investigation was completely veered in one direction, and that's to Melody Walker Farris. So much was left, and that's part of what you've seen in this case. We've been attempting to investigate this case because we ultimately feel that it wasn't. We believe that the complete ignoring of the barn is absolutely, it's just despicable, for lack of a better word. And because they never even looked over there, they never even used Blue Star or Luminol or intook any of those things, even though there were some clear signs that they maybe should have. Gary Farris's card was over there. Scott Farris's bathtub was perfectly clean. They're there. I mean, Michael Ray told you. He told you. We had all those boxes that sit back there, and y'all, I'm very analog. That's the way I am. So we had all these pictures, and I'm going through all these pictures for months and months and listening to all these interviews, and you guys have gone through most of those things. And sure, I got real frustrated one day. Michael's told the story, but I'm going to tell the story to you too. I think you need to know. So after going through this for weeks, preparing for this trial, hours and hours and hours, hundreds and hundreds of hours preparing for this case, I finally threw up my hands. My paralegal will tell you. Sometimes I throw up my hands and I'm out. Michael says, "Where's John look?" I don't know. So I have to go pick up my family's prescriptions at our local drugstore, and I go over to the drugstore. And there is this little, she's young. I think she's 17 years old. She loves to read. But I walk in and they're redecorating the drugstore. This is a drugstore that's been owned by one family in our hometown for about 70 years, Jasper Drugstore. So I go in there, get my prescriptions, and she's like, John, what's wrong? So I tell her, oh my goodness. And she looks at me. 17 years old, redheaded too, unrelated. 17 years old, she looks at me and she says, you know, Mr. Weaver, sometimes the greatest questions, they go unanswered. I mean, literally. Ton of bricks. The second she said that to me, it finally cleared it up. Because I've been running around trying to solve this case for 4.5 years. That's how long I've been on it. Mr. Ray was on it longer than me. But because it is not answered, that's a doubt itself. I want to talk about a lot of the evidence that has been shown about phone calls and sexual relationships with Rusty Barton and the grotesque amount of time that was spent by the district attorney's office proving a point that was proven very quickly. And that's that my client had extramarital affairs. But also evidence was shown that so did Gary. And they were in an open relationship. They lived on separate parts of the house. And Amanda, I thought Amanda was a truly fascinating witness. And it's kind of sad we had to call her. I think she's the only child that is impartial. She literally just looked at you guys and said, this is y'all job. I believe in my mama unless or until she's proven guilty beyond a reasonable doubt. And I think Amanda is such a credible witness because she also testified she was with her mama the day of the 4th. Nothing was out of place. And sure, they were texting and they were calling. And you see all this back and forth bickering all the time between them. And that's the Farris wheel. And the moniker that has come to be in this case. And I know we are all sitting on top of the Farris wheel, and we just can't wait for that ride to let us all off. That's y'all's job. And we're going to get there. But all of the drama and all of the infighting between the siblings and the affairs and the relationships that have gone on. I mean, the affairs started in the mid-2000s. You got Angela Phillips back in the 90s, who may or may not remember if she had sexual intercourse with Gary. All of that insanity. That's their life. But it's not motive for murder. And that is what they have put and leaned so much of y'all's time into. Because they don't want you looking at this. They don't want you looking at what they didn't do to get to their burden. But let's go back to those phone calls the night before. Let's go back to the timeline. There's something that is absolutely bizarre to me. We did not find out until, I think it was last Friday, when Commander Harris testified that Gary Farris went to dinner, we think, by himself, the night he was murdered. We don't know. We'll never know. He was at least alive until 9:30 something. When we see the dot moving, if the science is true. But sure enough, he went to dinner. They never thought to go get a video of that. Let's go up there, interview somebody. Maybe he was with somebody at dinner. We'll never know. And I'm not saying that breaks open the case. But I continue to use that huge glaring hole in the timeline right there. I'd say that's a doubt. Scott had been out at the lake all day. Golfing, laking. And there was a lot of testimony I heard about that and the life and the dynamic that he had on the farm. He referred to the farm as his. He referred to the farm as his property, it was his possession. I mean, his sister even called it kind of comical. But you saw, and we'll get to go back through any of those you want to go back through and see the communications between Scott and his father. What really was happening was that Scott was a grown man who had every second. So whatever they're saying about Melody has to at least apply to Scott. He was completely controlled by his father, financially. Bring me back that credit card. Where's my credit card? It better be in my wallet when I get back. Over and over and over. It's in the messages. You've seen it. You can go see it again. So that financial motive alone and that control, wanting something that's not his, I think that's a devil. The timeline of the phone calls. You will have seen from Commander Harris something regarding activity in phone calls. But I think that you guys have enough common sense to know, and this is just some things we saw, that other days and other times, you went back and extrapolated out over a year, sometime back in 2017, and we clearly saw that there was more activity the night before a baby shower in Nashville than would be alleged for Melody to have shot, killed, moved, and burned Gary Farris. This is no easy task. That's a doubt. All of the weapons that could have been used in this case, all of the bullets, the means, the ability, they started talking about those circles. They started zooming in on one person. And it's not Melody Farris. It's Scott Farris. He's sitting here today. All of it. But I think it starts to become clear why I'm doing this. Why am I dropping these bags? These bags are 40 pounds apiece. I've got a few more bags to go. But I want you to know that it starts to become very impossible when you add this up, that someone who weighs 120 pounds can move this. That is a doubt. In its own right. But there was a person on the property who could. And that's Scott Farris. He's sitting there today. This is 320 pounds. I am 185 pounds. And that's all I have. I think it is the heaviest out of all, that they have provided you with no means, plan that this could have ever happened by Melody. They have established there was tractors on the property and RTVs, but as my client, or as my partner very clearly laid out to you, I'm sorry. As my partner very clearly laid out to you, they didn't do their job. They've provided no way that you could have done this. They didn't check the boxes. They didn't fill any holes of doubt. The state of Georgia has put my client under grave suspicion. That is exactly what they have done. They have put on her grave suspicion, the most grave suspicion of all, and that is murder. But the doubt, I contend to you, absolutely exists. I'm sorry I had to do this demonstration, but they didn't. They didn't show you what 300 pounds truly feels like. I'm not saying I'm the strongest person in the world, but that is as heavy as a thing as a person can move. And I'm almost a 200-pound man. No explanation has been given. And I keep bringing this back because the grave suspicion that they put on her is affairs, calling Rusty, all of these things. And I want to note about Rusty as well. Let's note a few things. And I know you've listened to it and you saw it. Pope, he threatened to arrest him. He threatened his own warrants against him, the death penalty. Bugged my client for over a year. No confessions. Her own daughter has lived with her for years and years and years. No confessions. Now I want you to know this too. And it's a charge that the judge would give you. My client does not have to testify. She didn't. She chose not to testify. And we talked about this in jury selection, that you wouldn't hold it against her, but the law is clear. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Because again, the burden never shifts to us in the defense. I feel like there's been so much time that we felt like we're trying. I'm trying to get you to see the side of the story that was never investigated. I feel like we were able to do that, but we didn't have to do that. This decision in this case is everything for Melody. Melody has had to live under this grave suspicion for 6 years. But now is the time that 12 fair and impartial jurors, a jury of her peers, can finally give us answers. I'm not saying that you guys can ever answer what happened that night. The greatest questions, I do believe, they really do go unanswered. And in this case, and it may be some of you as it was me that day. Very frustrating. You want to figure out what happened. But it's okay to know that you can't. And I contend to you, ladies and gentlemen of the jury, that because you can't explain what happened that night, they have not proven this case beyond a reasonable doubt. And I ask you to please hold to your oath and find my client, Melanie Walker Farris, not guilty.